Hey everybody, welcome back to the Court of Random Opinion. My name is Neidigh. We've had a lot of documents appear on the docket today in the Justin Baldoni versus Blake Lively case. I'm going to be doing a condensed recap of each one of those, but first I want to talk about this motion to compel filed by Blake Lively to get the Wayfair parties to give her witness recordings and documents pertaining to an independent investigation into the alleged sexual harassment complaint made by Blake Lively. Now, Wayfair initiated this investigation after they learned of Blake Lively's sexual harassment complaints when she made her complaint to the CCRD in December 2024. However, Blake Lively's attorneys are calling this a disingenuous charade, saying it happened years too late and it should have happened when she made the complaint in the first place. Of note, there is absolutely no evidence to suggest she made a real sexual harassment complaint, so this all feels pretty disingenuous to me. Sony has denied receiving any complaints. She didn't go to her union with any complaints. And the return to production demands that she forced Wayfair to sign or else does not constitute a sexual harassment complaint. Regardless, she is now trying to stop the investigation into her claims. They write to the judge saying that Wayfair is refusing to give them information, recordings, documents, whatever, relating to this investigation. However, that investigation is ongoing despite her multiple attempts to halt it. They complain that the investigation has gone on for nearly 5 months, and saying that Wayfair is conducting one-sided interviews where they decide who the witnesses are, and they're complaining that this investigation should not be going on at the same time as these lawsuits. What they failed to disclose in this letter to the judge is that they actually had the opportunity to give names of witnesses who should be interviewed for this investigation, and that Blake Lively herself was invited to participate, but she refuses. The document includes exhibits that show correspondence between Blake Lively's attorneys and the firm that was hired to do the independent investigation into the supposed sexual harassment claims. They say a failure to investigate is unlawful, however, then they refuse to participate and complain that this investigation should not be happening at all. As far as whether or not this should be happening while there's pending lawsuits, that's something that, the attorneys or law tubers are going to have to answer for you. I couldn't tell you that. What I can tell you is that there was a lot of unnecessary mudslinging here, a lot of mischaracterization, and way too much protest from the woman who claims to have been sexually harassed, but doesn't want to be interviewed about it, but does want to go on talk shows and declare herself a champion for women and girls' safety. The firm states, the scope of our investigation includes whether Miss Lively filed complaints and whether Wayfair failed to investigate them. Blake Lively's counsel says, your efforts are misleading, and they threaten to taint witness evidence in the case, and they must stop immediately. Blake Lively says the firm's efforts are misleading, and they threaten to taint witness evidence in the case. In doing so, they accuse this firm of failing to disclose that their neutral investigation is paid for by Wayfair. They accuse them of misrepresenting their role and their relation to Wayfair. They wrote, we hereby demand you immediately cease and desist from further pursuing this sham investigation and from contacting any additional witnesses as part thereof. Cease and desist from further pursuing this sham investigation. Wouldn't it have been nice for somebody from Wayfair to have been able to do that with the Van Zandt John Doe lawsuit? The firm doing the investigation writes back, your demand is baseless, procedurally improper, and substantively indefensible. You are undoubtedly aware that the approach we have taken reflects not only legal compliance, but standard workplace investigation practices. Your letter reflects a willful mischaracterization of our role and the protections afforded to such investigations. Your letter appears designed to obstruct a lawful process and chill the participation of witnesses who might otherwise assist in a fair, impartial fact-finding endeavor. We are not litigation counsel to Wayfair and do not operate under any litigation or public relations strategy. We conduct our work free from external pressures, including those arising from pending litigation. Your assertion that we have been bought and paid for is disingenuous. Your claim that our investigation is a sham designed to interfere with litigation is equally baseless. Your allegation that we have misrepresented ourselves to witnesses is not only factually incorrect, it is reckless. Your accusations appear aimed solely at undermining the credibility of fellow members of the bar without cause or justification. We see no lawful basis for ceasing an investigation authorized by federal and state law, and we have no intention of doing so absent a court order. Your cease and desist letter constitutes unlawful interference with an ongoing investigation and is plainly meant to try to intimidate participants and obstruct the process. So those exhibits are showing the correspondence back and forth, but this motion as a whole is trying to compel Wayfair to give them the contents of this investigation, which is ongoing. Whether or not they have the right to do that, I don't really know, but I'm sure we're going to find out. Thanks, everybody. Appreciate you watching, and I'll see you next time.